Good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today, again, not necessarily a surprise, as a lot of the people were just talking with the guest here about how many were students and classmates of mine at Osgood many moons, maybe not many moons ago, but so certainly I really appreciate them taking the time and joining us. So today we have Amanda Driscoll joining us here, who is a lawyer and workplace investigator at Mortimer Corrich Workplace Investigations and Restoration. So thank you, Amanda, for joining us.
Thanks for having me.
Now, Amanda's, like we had said, it's been a while since we were in school together. We'll just call it a while, and people can fill in the years from call dates and things like that. But perhaps maybe you could tell us a little bit about what led you to what you're doing today, from Osgood to today's practice.
Sure. So after law school, I articled at Aboriginal Legal Services of Toronto, now just called Aboriginal Legal, ALS, Aboriginal Legal Services. They dropped the Toronto a couple of years ago. And after articling there, I then got to practice there for 6 years, which was really great because when we were articling, there weren't a lot of lawyer jobs. It was really tough to get an articling position, and then even to walk into a full-time lawyer position was great. I think I had a very different articling and couple first years experience. I was helping on inquests when I was articling. I was helping on Supreme Court matters. Just really thrown into the deep end and had to figure out how to swim, whereas some of our classmates I know had a bit more structured learning environment and maybe a little more menial tasks than what I dealt with, which was great because it actually taught me more than what I probably learned at law school, which is, I know, terrible to say, but definitely it was a great learning experience. And then when I was practicing as a staff lawyer there, the type of work I did was extensive, a lot of income support, so ODSP appeals and OW appeals, and then some Court of Appeal, Supreme Court, and inquests were a big part of what we did as well, and police complaints. I did a lot of police complaints, which I think probably led me to where I am, that whole trying to understand what happened and figure out who was doing what and why somebody's bringing a complaint forward, and that desire to seek justice for feeling wronged. And after 6-7 years at ALS, it was a little bit much. It was very draining emotionally. It's a very difficult practice because the wins sometimes are few and far between, which isn't really why we get into law, but it kind of felt like hitting my head against a brick wall some days, and that can take a toll. And so I thought maybe it was time to find some new work and broaden my experience because I had articled and then practiced there. So an opportunity came up at the Ontario Ombudsman's office to be an investigator, which was completely different. I thought that's not even practicing necessarily. It's just completely procedural reviews, policy reviews, an administrative body essentially, which was basically the practice at ALS, all administrative law. So I was there for 2.5 years, just over 2.5 years. And just when I was starting, they had taken on new jurisdictions. So they had just recently received jurisdiction over municipalities and school boards. And that was a huge, huge jurisdictional on-take. Like it was so many, it's for all of Ontario, there's a lot of school boards, probably a lot more than people think. And then municipalities had never had any oversight. So it was a lot of relationship building and a lot of pushback there, I think. And I was able to work on one of the first municipal investigations that the Ombudsman's office undertook, which was a really interesting experience, and learned how to do investigations from an administrative standpoint. So more policy based, more looking at, did people follow the policy? If not, are there gaps? How do we address those kinds of issues going forward? The thing with the Ombudsman's office is there's not as much teeth as I think I would like there to be, because the ombudsman can make recommendations, but it's up to the institution, governmental, municipal, or school board to make those changes. which I guess isn't much different from what I do now, because as a workplace investigator, you can make recommendations, but it's up to the employer to take on those. And so after a few years there, gaining experience, cutting my teeth, as they say, as an investigator, I knew I wanted to go back into practice. I had had a nice kind of break from the practice of law, so to speak. And then I thought, I do want to go back to practice. I miss that further engagement that you had with the legal aspects of investigations and policy. So I went to another, it's a investigations employment firm, and got more great experience there, but just different work investigator experience, because it was employment law based. It was definitely all practice based, whereas at the ombudsman's office, I was a non-practicing investigator, and not as much engagement with the law as you would in a private practice. So it was a big adjustment as well, because at the clinic, we didn't really docket in the traditional sense. Like, there was not 6-minute billables. And so that was a huge adjustment for me, having to docket every 6 minutes of my life. Definitely don't love that. And then, yeah, you find where you like to work, and the flexibility of working at MKPC is great, because I can work from home. We have virtual offices even pre-COVID, so it's kind of nice to have that flexibility, and a little more flexibility about the kinds of work I take on. So it's just all kinds of different cases. Whereas at the ombudsman, it was very specific, like it was only governmental bodies, anything that the ombudsman had jurisdiction over. And now, as a workplace investigator, I get to do training, I get to do workplace assessments. So that's, basically taking the temperature of the organization, doing a culture audit, and then also doing workplace investigations.
Perfect. So there's a lot in there in terms of different steps, and I think that's good for certainly both law students and anyone listening. We often, I think, when we were in law school, here's the path. You go and do this, and eventually you become partner and retire, and you have a cottage life or something to look forward to. But again, from doing this, talking to so many different people, there's so many different paths, and I hope students understand that whatever you're thinking about, you may move around into different directions. And so even what you started from articling, and then 6 years at ALS there, maybe you could tell us a bit more. I mean, maybe about inquest. I don't think we've certainly had that come up in class, certainly, about what kind of work that is. And again, you're getting more hands-on experience because you're thrown into the fire, so to speak, because you're a resource. They have limited resources, as you can probably attest to, and they got to take advantage of you, right? They don't have time for you to kind of slowly come into understanding. So maybe you could tell us a little bit more about what you did there, and what inquests are, and the different kinds of work in a little bit more detail.
Sure. So for inquests, ALS would often represent families of individuals who died, generally, unfortunately speaking, from police incidences. So usually they were either injured with a police officer, or some type of weird situation where the death is uncommon. And so under the Coroner's Act, there's an obligation to investigate those deaths. Also includes correctional facilities as well, provincial correctional facilities. And the Coroner's Council is an independent council. They represent basically the coroner. So they present the evidence. There's no finding of wrongdoing necessarily, but the family of the deceased individual is entitled to counsel. Sometimes it's funded through the Ministry of the Attorney General. Sometimes it's not. Most often we did it pro bono, being from ALS. ALS is funded from Legal Aid Ontario, but they're a specialty clinic. They're kind of different than the way normal legal aid clinics work. And then sometimes we would join in as basically an intervener party. So a party who has interest in the outcome of the investigation. So there were a couple that we did that as well. One of the first cases I worked on was involving a family member of one of our employees at ALS. And then we also worked on the 7 Fallen Feathers inquest at the very, 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 very start before everything kind of went off the rails and restarted, and led to the whole jury role issue, if anybody's familiar with that. And so an inquest is quite different than a court proceeding. There's witnesses called and the evidentiary requirements are all there, but you're not trying to prove that somebody did something wrong necessarily, and there's no outcome at the end where somebody is charged, or, well, I mean, could happen, but it's rare. But at the end, they're just looking for recommendations to make sure that the same incident doesn't happen again. So you're representing the family, but you're not necessarily looking for some type of outcome where you either get restitution or somebody's charged criminally. So it's significantly different than that. And it's just a little different because in these types of situations where the police are involved, there's multiple parties. There's usually a lawyer for the police officer, a lawyer for the police association. And so it can get very big, very quick, and have a lot of different players. And although there aren't necessarily negative findings, or like anybody's being held criminally responsible, it does impact the officers and the police boards and the police organizations, wherever the incident took place. So there is some friction, obviously, between the parties. So it's not always obviously a comfortable situation to be in. It's very difficult to go through them, even as counsel, because it's an emotional situation. Evidence comes forward that maybe you weren't anticipating, and you aren't prepared for the emotional impact that it can take on your client as the family, having to listen, often looking at pictures and videos, or any type of documentary evidence that comes forward. So it was definitely a lot of work, and a lot of emotional work. And I think that's the big thing about working at ALS, was that emotional aspect and that human side, because you have that direct contact with the client on a regular basis. And often they're not in their best position in their life. So it's never a fun position to be in, to be there helping them along.
And you'd mentioned there it's kind of like banging your head on the wall repeatedly. What can you share from maybe people who might be looking into getting into fields like that, or any area of law where often you're finding struggling through difficult times because you're not seeing the fruits of your labor, so to speak, that you've put in all this effort, and the results keeps coming up not what you were hoping for. What kind of got you through? I know ultimately after 6 years, you said that's all I can do, but what kind of got you through those times where you found that, you weren't getting the expectations, the reality wasn't meeting the expectations and hopeful results?
Yeah, I think a big thing is having a good mentor, or having a good support system internally in the organization that you work for. ALS is very much like a family, and there has never been another workplace like that for me. It's completely different in that sense, which helps, because if you're working in a silo and you don't have anybody you can lean on, then that opportunity to feel revigorated, or have a debrief after a difficult court case, after a difficult meeting, after a difficult hearing, you don't have that opportunity. You're not going to feel like you are debriefing, or that you're having a break. Also, having great mentors and people who have been there a lot longer than you, they remind you that it's basically the squeaky wheel gets the cheese, right? We don't see the big wins day to day, like maybe some litigation lawyers see, but eventually there is change, and the only way to make change is to fight against it. So you can't expect there to be change overnight, especially in some of these systemic matters where it's just the same thing over and over. Like inquests, we started to track the number of deaths by police officers, because we just kept seeing the same thing. Like if people remember the subway incident, like that was just another example of many in the last couple of years around that time where it was a police standoff and somebody died as a result of mental health, lack of mental health supports, and the police not having great training and all of those issues. It was just another case. But if you don't participate in those, then who is speaking on behalf of the vulnerable people? So keeping that in mind definitely kept me in check, and taking care of yourself. I know it's probably fluffed up a lot or offered up as a quick fix, but you do have to take time to step back and take a breather and then re-engage. But knowing that over time there is change and you're just helping put that change forward, it got me through a lot of difficult times. And then those wins, those big wins when they happened. One case that I worked on was R versus IPLE. It was at the Supreme Court, and it was an expansion of the GLADU principles, and that was huge success. And it was nice to see the court understand what we had been talking about for years. You know, GLADU doesn't just apply to sentencing, it actually applies outside of sentencing. And then we've actually now seen it expand into even disciplinary proceedings at the Law Society and at other administrative bodies. So it's, you know, it's those one decision that can actually trickle down. And when you see that, you're like, okay, yes, that was what we were doing. So.
Yeah, that's great. I mean, obviously, then anytime there's ever sort of an issue like that, you could say, well, I was involved in extending that principle beyond just the sentencings there. So, I mean, again, that trickle down effect, as you pointed out, even years later can help turn someone's life around, right? And you may not see those wins, but they're there. Just don't come to your attention, right? So it's great that that there are a lot of things like that a lot of those accomplishments that you can kind of treasure, even though there are those difficult times. You mentioned mental health, and usually we talk about this towards the end, but since you brought it up, probably a good time. What can you share with students, whether it's maybe in law school, whether it's during the articling time, or even now in terms of practicing or any time during your practice? How you mentioned taking care of yourself. What are some ways that you kind of had a chance to reflect and take care of yourself there, even though as you can tell, right, in terms of our profession, there's a lot of stress and anxiety, and again, a lot different, I think, than 20 years ago, but still, I mean, how do you kind of cope with that, and what can you share with students who may be going through difficult times?
Yeah, law school was difficult. I think, yes, it gets easier every year in a different way, but every year brought challenges. And so I think a good thing was having a good core of group of friends. And I think we were fortunate in our section. We all got along pretty well, even if we weren't close friends. So I think that helped first year, being able to find like-minded people and know that you all have the same ideas or the same beliefs, and why you're at law school is pretty similar as well. And then, yeah, I guess it sounds kind of silly to say, but taking time. So knowing when you're taking on too much. Saying no is probably a hard thing for a lot of lawyers or people in the legal profession. I think we're all pleasers to a certain extent. So learning to say no definitely helps, and taking a step back when you're feeling that overwhelming sensation. Osgood also had a really great support system in our deans and in our administrative team. I had suffered a very tragic loss when I was in law school. I lost my dad in second year unexpectedly, and the law school supported me through that. So knowing that there are supports in place in your organization, in your school, in the firm, is, whatever situation you're in, I would think if they aren't there, probably not a good example of how they're going to treat you or how they're going to, consider mental health issues or physical health issues. And I think that has come across in my other professions. At ALS, there was a lot of opportunity to take time off when needed. Not just for myself, for any of my colleagues who maybe weren't lawyers. We had paralegals, we had social workers, we had community workers. So, ALS had that built in because of being an Indigenous organization. So that was obviously at the forefront in that organization. extended bereavement leave, spiritual days, cultural days, a lot of team building. I think team building is important. Maybe some people don't put as much weight into that, but I think it does help the team, because then you feel supported when those big issues come up, and you feel like you have somebody you can go to and say, I'm struggling, or I could use some help in this area. And same with the firms and other organizations I've done work with. They've been great and put mental health and stress at the forefront, and have said, we're going to do training on self-care, and we're going to do training on mental health for the profession. And then we're going to talk about what you need to make sure your practice is at its top, at the peak. So that, I think that's key, is having those supportive networks in where you decide to work. I mean, I would hope that if I was in a situation where that didn't exist, I'd probably step back.
Now, I see a question in terms of investigations. Now, you mentioned certainly the ombudsman's office, and then from private practice, and in one, I think you were not having to practice, whereas in the other, you are practicing. Can you maybe explain why, how there's a distinction where, as an investigator, in one that you don't need to be a quote unquote practicing lawyer, but in the other, you still need to have your license and be in good standing and such.
Yeah, actually, I think I do know some workplace investigators who aren't lawyers. There are paralegals, so licensed as paralegals, but and also HR professionals who do a lot of workplace investigations or workplace assessments. And I think the whole point of any investigator is that you have some type of background in policy assessment and understanding policies, understanding legislation. So HR people are generally pretty up to date on, what the current regulations are around either dismissal or, having to give sick leave and stuff like that. So they already have an understanding of that background. In the ombudsman's office, there were lawyers who were also investigators, and then there were investigators, and most of us, I would say almost 90% when I was there, were legally trained, but there were people there who did not have any legal background whatsoever. We had a lot of new calls for a while as well, which is great because it's really great opportunity to gain some experience. A lot of great work done there and a lot of opportunity there as well. But I think just from their perspective, from the organization's perspective, they didn't want the public to think that they were being dealt with a lawyer, because that changes the interaction. And so it was easier to say, they're a workplace investigator. And when it first started, I don't think there was an intention to have lawyers be the backbone of the organization. So I think that changed over time, but knowing that lawyers can analyze policies and procedures and sift through mountains of paperwork probably is what changed that dynamic and brought more lawyers into that.
Okay, perfect. And then sort of related to that, maybe maybe let's take a step back and perhaps you can go through the process of, let's say, a clinic or education institution or an organization, whoever comes out and says, Amanda, can you come in here? We're experiencing, maybe a toxic work environment. What's going on? Or someone has a complaint about a superior. How does that process kind of play out? And maybe you can just kind of walk us through.
Yeah. So normally an external investigator is brought in because the internal person, whether it's an HR manager, generalist, or even an internal investigator, they may be too close to somebody involved in the investigation, or there's a concern about some type of perceived bias. And workplace investigations are supposed to be neutral, impartial, and have no bias. So if there's any ounce of there being a possibility that somebody may say at the end of the investigation that the investigator was biased or the investigation was biased, I think employers and organizations are really quick to just go external to prevent that from being an issue. Especially like the investigation process can be traumatizing for parties. And so to go through a whole process and then have that come up as an issue and then have to redo it, that's not really what employers are looking to do with their time or their money. And so sometimes files will come to us either directly from the employer or through their external legal counsel. And it's really just trying to find a good fit. So I have specific experience. Obviously, I have experience dealing with Indigenous issues. So, I have a different set of experience than my colleagues who are also investigators. Some people have more experience dealing with like nonprofits or large corporations. So finding the right investigator is also important for the employer. You want to make sure there's a good connection and that they know the issues that might be influencing the workplace. And then once all the, minute details of how long is it going to take, and who's involved and what are the main issues, I generally just get started by talking to the complainant and getting to hear their story, depending on what the situation is. Sometimes I have a bit of background. Usually it's minimal. They may have filed a formal complaint, like a written complaint. Sometimes they're anonymous complaints, so I don't even know who the complainant is. So I have to speak more generally to a selection of employees who we think may be involved, like one of them may be the complainant. But in the situation where it's an identified complainant, I've found that most of the time, even with a written complaint, there are other issues that they haven't put in because they might think that they're too dated. They might not think that it's important enough. So often in that first meeting, the kind of allegations that come from that complaint expand most of the time. And so from that, I do develop what's called a summary of allegations or a statement of allegations. And that's basically an itemized list of the concerns being brought forward by the complainant, either against an individual, a group of individuals, or the workplace generally. And then that statement is given to the respondent, so they have the opportunity to review that in advance of meeting with me. And I know there's some workplace investigators out there, mostly I would think in the States, they kind of like the surprise attack, like don't give any information to the respondent and just meet with them and kind of surprise them with what's going on. But that's not a good practice in my mind. I don't think it's fair. I don't think it allows the opportunity for an open dialogue. If you are surprise attacking them, then I kind of feel like there's a bit of bias there as well, because you're favoring the complainant in that situation by treating the respondent differently than the complainant. And that's important throughout the investigation, that both be treated the same, allowed the same opportunity to provide documentation, to have time to review any evidence. So once the respondent has a chance to review that summary, then I would meet with the respondent and get their evidence. And then usually from both of those interviews, they would identify witnesses that I would think about interviewing. One of the things that's important in a workplace investigation is ensuring confidentiality of the parties. So we always assess whether or not we need to speak to witnesses, because once you start speaking to witnesses, that ability to control information grows a little bit each time. And sometimes people will name a witness, say that they were present or that they overheard it or that they were told about the incident, and then the witness doesn't know anything and now they know about the investigation. So it's a fine balance of trying to make sure you get all the information in order to make those findings, and then not interviewing everybody under the sun just to have that opportunity. And then after all the interviews are done, sometimes there's follow-up interviews with the complainant and the respondent. And that's generally when there's been some type of evidence that's come forward that the complainant either didn't speak about, or it completely contradicts their evidence. And so they're allowed the opportunity to respond to that, especially if I intend to rely on any of that evidence in my report. It would be unfair to make any findings on evidence that somebody hasn't had the chance to respond to or address. And then, and throughout that whole process, you're collecting any type of evidence, documents, texts. I've had Snapchats, I've had videos, I've had security footage. You name it, it's out there. And then after all of that, you prepare the report. And generally, we're asked to do factual findings. So, did the incident happen as alleged? And that is done on a balance of probability standard, so much different than criminal. So, we use the kind of 51%. Am I 51% sure that this happened as the person is putting forward? And then sometimes we're also asked to do a policy analysis. So, does the conduct, if true, violate any of the employer's policies or procedures, or the Occupational Health and Safety Act, or the Human Rights Code? And then rarely, but it does happen, and I like when it happens, the employer asks us to give recommendations on what to do next. But again, they can take the report, read it, and make their own decisions regardless of what I put in there, and regardless of what recommendations I put in.
Right. So I guess that was what I was going to ask in terms of, you mentioned like, the teeth there before. I mean, and still, do you ever find out kind of what happens after you present the report? I mean, is there any further correspondence, or do you just kind of move on to whatever else you need to take care of?
Yeah, generally not. Once it goes to the employer, I tell them, like, please don't let me know what you do. That's up to you. I don't want to know. I don't want you to even suggest what you want to do, because I'm not involved in that decision. There shouldn't be any indication that I was involved. But obviously, sometimes I've had complainants or respondents follow up with me afterwards by email to tell me what happened, and I just filed that away. Do not respond. Or you hear about things like in larger organizations, you might hear because there's shifts in the workplace, and you hear about that. Or there have been times where we can be brought back in to do coaching after an investigation or a workplace assessment, because the issue was more than just one or two people. It might have been a more cultural issue. So then when you're brought back in to do that kind of stuff, you get an idea of what the employer is wanting to do and what they have done.
So then there can be certainly employers or companies, whoever, I mean, do they kind of retain, let's say, the firm just for anything that comes up? And then if there's no retraining or training or anything, coaching, as you said, then you would do some follow-ups depending on the kinds of situations? Or is it more so you'll be brought in for a particular allegation, and then maybe if there's something in the future, they'll call you back?
Yeah, more of the latter, where something comes up, we're brought in, and then maybe there's some type of secondary requirement after the investigation, and then generally, they get comfortable with the investigators, so they ask for them again because they liked the way they worked well together. I mean, it doesn't happen every time. You can't get along with everybody, but I definitely have had the experience where the employer has liked the report, has liked the way I dealt with it. And so they'll come back in a few months or a year and say, oh, we have this new issue. Can you help us with it? And so it's great in that way. I think there are firms who are retained, investigators that are retained to deal with specific companies. And I don't think there's anything wrong with that necessarily. I would just be worried that over time, you might start to lose your edge on the workplace, because you've become so accustomed to what's going on there that maybe you kind of have now blurred that line on impartiality.
Yeah, I mean, there's a good question here about, do you ever worry about conducting thorough investigations and giving maybe too honest opinions, where the employers get the bad dark side there of what's going on, and then they're like, oh, I didn't really want to hear that, Amanda, we're not going to come call you back the next time. I mean, given what you just said there about what sometimes you get so insulated because you're hearing all of the matters, then it may lead to a lack of impartiality. So have you kind of ever looked at, when you put something in a report, should this go in there? Or again, do you have to look at it, well, this is what I've been told, here are my findings, and it's up to the company to kind of sort out the process later?
Yeah, definitely. I think it's a balance throughout the investigation. Every ounce of information that you receive, every evidence piece that you receive, you have to assess whether it needs to be in the report, because you could easily put everything into a report. It would be very long, it would be cumbersome to read, and it wouldn't really address the point. But you also have to make sure that you are putting in evidence that's responsive to the concerns being raised. There are obviously situations every time where somebody raises something outside the scope of the investigation. So, when an employer engages an investigator, they'll say, this is what we want you to investigate. This is the mandate and scope of the investigation. And you're not to go outside of those parameters. Whenever something new comes up in the investigation, I let the employer know, and it's up to them to make a decision whether the scope of the investigation gets expanded. But also, if an employee brings a complaint against their manager, and then in the course of their interview they mention something that happened with a colleague that's not in the investigation, I have to let the employer know. I have a legal obligation to tell them at that point, and they have a legal obligation to follow up on it. So whether I do the follow-up and they've asked me to, expand the investigation, or they do it afterwards, it's definitely up to them. And I think, it's probably a lot, because you're trying, as an employer, you're trying to focus on the one issue, and it could be that there's a lot more going on in the workplace. And generally I think they have an idea, if there's gossip in the workplace, that's a good indication that there's something going on, not just one thing. And statistics tell us that where there's one formal complaint, there's likely several more, and several more outside of that particular issue as well.
So, given all of your experience there, and certainly in looking at a lot of these situations, what can maybe, before a situation were to happen, what can you, I mean, I know it's very general here, but in terms of different, workplaces, education institutions, what are some, maybe in terms of either policies or characteristics, or just things that they can create or act in to avoid a lot of the situations that you've seen? I mean, obviously the best way is to avoid having to reach out to external investigators. I mean, deal with the potential problem and solve those before they could even happen. So what can you share, kind of from looking at a number of these incidents, of how they could have been avoided in perhaps the first place?
Definitely communication is key. So whether it's, stopping those gossip situations from happening, if you hear gossip, there's probably more to that. So looking into what that's about, and then also training. I know it sounds kind of silly, but training is an important part. Under the Occupational Health and Safety Act, in Ontario, employers must train their employees on workplace harassment, sexual harassment, and discrimination. And what we see often is that's done when employees first enter an organization, and then it's not often updated or retrained, or it's a simple sign off on a policy. So they sign the back of the policy saying that they read it, but there's no engagement with the material. So I think people have a hard time understanding what is harassment, what is sexual harassment, what is really discrimination. They think of these in these really big umbrella terms, and there can be all these smaller smaller issues underneath all of that. We deal with microaggressions that used to never be a thing that people were aware of. So every day it changes, and things grow, and the practice grows in that area. But people being trained on what are those things, what do they look like in reality, walking them through scenarios of what is proper workplace conduct is a good first step. Having a strong policy and procedure in place, also required under the Occupational Health and Safety Act, but not often shared with employees. There was a recent survey that said most employees didn't know that there was a policy or a process in place to deal with complaints. So what happens is people hold on to these issues for years and years and years, and then finally something happens that they just can't take anymore, and it kind of blows up. And that's where we see those, multiple allegation situations where people have years of complaints, and the employer's like, I had no idea. But it's because there was no communication from the employer to the employees. And I think for me, when I read these kinds of reports and from my experience, I think the leadership from the very top has to buy into it. You can't just say we have this great process, we have these policies, we have, we have a complaints tips line, but if you don't walk the walk and talk the talk, then your employees aren't going to care and they're not going to buy into the system either.
And that's great there, because obviously it does, it's part of the whole culture of an organization. If you see it as, they're just paying lip service just because, someone in HR said, hey, we should do this, then I mean the results are not going to be there, because nobody wants to really go forward, because they know it's not going to go anywhere. Now, I mean, we've also seen in recent years, especially in the legal profession, attention paid to EDI initiatives, and certainly I'm sure you've had, even given the lens of maybe just on the Indigenous side, issues that come up in different organizations, workplace, where there's just a lack of proper care given to that. What have you seen? Maybe if you can elaborate or share in terms of that aspect of what can be done, given the maybe the lack of full and proper attention to this for many years, and how that creates a culture we were just talking about, where there's that glass ceiling, so to speak, where only certain people can kind of advance. What have you seen and can share in terms of your experience there in investigating maybe situations like that?
Definitely, we've seen that. I think one example comes to mind is even highly educated people have the belief that they can't be racist for whatever reason, and then they go and make comments or speak in pretend to have an accent that doesn't belong to them, that's derogatory in nature, and don't think twice about it because everybody else laughed or nobody said anything in the moment. And not that there wasn't a lack of training or knowledge in those issues, but that the organization didn't maybe give enough information about what does discrimination look like. It's not just this term that we pull from the Human Rights Code. There's all these underlying issues, and you have to see what those can look like to another person. I think that's one of the ways I've seen it manifest in investigations. And then obviously we see it a lot in terms of hiring practices. And that's a really hard thing to prove, that the hiring practice is systemically discriminatory, because what is the check and balance for that? You have to look at every part of that process, from the posting to the selection of the people on the panel who interview people or who review applications. So those are some of the bigger issues I've seen in workplace investigations, and I think it comes back again to transparency and communication. Often when there's a lack of transparency in an organization, people get upset. They feel like something is wrong in the system because there's not that open dialogue or something's being hidden. And so it's obviously easy to say that something is wrong and I'm being treated differently, but it's hard to prove that if you're not within the system and you're the person on the outside. And then, having to bring forward evidence that you don't have is probably a difficult thing to do, but that's what we're there to do, is to dig deep and get that information. So we've had people say, I know that this is a systemic issue, I just can't prove it. I've seen it in, multi-million-dollar organizations as well. And it's true, the evidence, the thing about systemic racism, as the Human Rights Tribunal has said, is it's often subtle. It's not in your face. It's not evident right away. So those investigations where we have to engage with that material is a little more difficult, because it does come down to, the person's, how it's impacted the person. And then also, what does the evidence say? Because it's not just objective, it's also subjective.
Now, another thing there, I mean, actually, I'm teaching a legal research and writing class, and I think maybe I had actually, I don't know if you had him, instructor many years ago on last year. So again, maybe you've done a number of reports, and I think obviously important there in terms of writing decisions and recommendations. Maybe you can share some writing tips, whether just legal writing or just general writing tips, because students are learning both legal communication and legal writing. Anything in all of those reports, or even all those memos and stuff you've probably written, going way back to the legal research and writing class we had at Osgoode in first year. What's kind of stuck with you, and what can you share with us?
Um, Definitely be organized. However it is for you, whatever your organizational process is, being organized is key. So for me, I have a lot of folders and subfolders to put everybody into their folder and their evidence into a folder. Sometimes these reports can be upwards of 100 pages and have, 50 odd appendixes. So keeping track of the evidence, whether you use a template or some type of chart, being able to track all of that, remembering where it came from, who provided it to you, what does it relate to. So having some type of system in place where you can cross-reference things. And I think something I learned very early on was, when you're doing your research, always save or bookmark your source, because you might forget to, and then it's gone. And it's really hard to sift through all of that material to find that one source that you need to cite, and obviously cite all your work. But I think there's some really great courses offered by the Law Society, by Jane there at the Law Society. Well, she's private, but she does a lot for the LSO, and she does a lot of great writing courses for lawyers. And I think I like to be florally, I guess, sometimes maybe add a lot of detail that isn't necessary. So just, first draft, get it in. Second draft is going back over and taking out what doesn't need to be there, because we have a tendency to add in a lot of detail at the start, and then you kind of pare it back to what needs to be there to respond to the legal question that you're trying to address.
That's great. That's some great writing tips there for everyone. Maybe getting ready to submit an assignment for me. The other thing there for students, I mean, as you mentioned, I know I teach a lot of paralegal students, and you don't have to be licensed to be in workplace investigations, right? I mean, and certainly paralegals are obviously licensed as well. Maybe you could share kind of any advice for anyone looking to get into this, and what are some options that you can do if it is right for you. And again, because you don't necessarily have to be licensed, what you can kind of do to get some experience, if this is a path you want to get into.
Yeah, I think one thing is obviously having some employment background if you're going to be doing investigations related to the workplace. HR, any type of HR courses, any type of human rights courses or background. I think that's what probably interested my employers, is the fact that I had administrative law and human rights backgrounds, because we also did human rights applications at the clinic as well. So having some of that as a background, not necessarily practicing it, but having knowledge in those areas is probably a good thing to do. I actually had somebody from Correction Services Canada reach out to me. They have done investigations internally as a correctional officer, and they're getting ready to move into a new career, and they want to do workplace investigations, and they wondered how. So those are some of the things I recommended. And then also there's associations, there's courses. The Law Society provides courses. The Association of Workplace Investigators, it's based out of the US, but they have a lot of great resources, and they're not all legal professionals. They have an intensive course that they provide as well. It's 4 days of intensive investigative practices. There's some great books out there. Janice Rubin and Christine Tomlinson wrote a really great book on workplace investigations, and it's more based from an HR perspective or an internal person's perspective, like how to do it internally. So that's a great resource as well. And really just taking the opportunity to learn about the practice of workplace investigations. Every investigator does their work differently, and we all have our own little things that we do and processes that we do, but the basis of investigation is that it's impartial, it's unbiased, it's done by a neutral third party, that everybody ensures fairness, the investigator ensures fairness in the process, that it's done thoroughly, and that it's done in a timely manner, and that confidentiality is respected. So as long as you can meet those criterias, I think you have the opportunity to work in this field and do great work in the field as well.
So you mentioned an American organization. Is there like a Canadian equivalent, or is there like a regulatory body or anything like that?
No, not at all. I am a member of the AWI. Lots of Canadians are. There's a Canadian chapter of it. So, like a local working group, like I guess subcommittee working group. So, all the Canadian people who are a member. I know some people will take the private investigators course because it's kind of relevant, like, in terms of gaining evidence, and sometimes you do have to do surveillance for investigations. You need to hire somebody third party, but you'd still have to go through that material. So being able to understand that, I do know some colleagues did the private investigators course. So I think there's some value in that. A lot of people also like taking ADR, and it's relevant, especially if you go on to do coaching or you do workplace restoration. Then that's super relevant because you're dealing in conflict in that situation. Even in investigations, it's a conflict situation. So having some ADR background is also really great. But no Canadian counterpart. And there's like an international organization too. So there's lots of opportunities outside of Canada and the US to do this type of work. Like even the UN has investigative units and stuff like that. So it could take you places.
Yeah, so on that point, I mean, has it been different in COVID? And I mean, in terms of, I mean, previously, did you actually go into the workplaces and meet with people in person, and now you're doing it over Zoom? How does that kind of affect, your investigations? Can you kind of compare from pre-COVID to COVID, or I don't know if you're back kind of still doing things in person, but I just thought of, you were mentioning internationally there. I mean, certainly nothing can stop you now from doing stuff in the US or overseas.
It has been a change. Previously, definitely in the workplace, maybe not directly. Usually I try to have a private place outside of the workplace so nobody can see parties meeting with me, because that always draws attention. But generally, always one-to-one interviews, in-person interviews. It just helps build the rapport with the person. It makes it easier for them to discuss with you and to build trust. Also, you're often exchanging documentation, so it's nice to be able to get that in person rather than piecemeal through email. And then COVID hit, and there was no option to keep doing it in person after a while. It trickled. It took a while, but I think the big difference for me is in situations dealing with sexual violence, it's difficult to sit on a screen and talk to somebody about something that's very violent in nature or sexual in nature, because it's different than the other situations of bullying or harassment. So I do find that it's a little bit harder to provide a trauma-informed practice virtually, but it's either nothing or that. So unfortunately, we've had to deal with doing it virtually. And it's just a matter of making sure you allow breaks. We allow support people to attend as long as they're not involved in the investigation. So offering that to the complainant and respondent, and giving those supports, taking breaks, washroom breaks, turning off the camera for a little bit, anything that helps somebody feel comfortable with me. I'm excited to go back into workplaces. I like that face-to-face, like actual face-to-face, but it's been slow. Obviously, employers are hesitant, and I think they want to have the employees back first before they start bringing in third parties to meet with their staff. So eventually we'll get there. I think beforehand, it was definitely an argument, like you weren't to do investigations. Even telephone interviews were like the bottom of the line of what of gathering good information. In-person interviews is the top-notch, requirement. But now I think being forced into this situation, we have no choice. And I think it's going to be hard to argue otherwise, that you can't continue to do it this way. I think from an employer perspective, they would probably like to keep it virtual, because it definitely cut costs. Obviously, investigators travel all over Canada. I've done investigations in Alberta. And so it's, all those things factor into the cost of investigation, and the cost can increase very quickly, especially with lengthy complaints. So virtual, there's no costs involved with that generally, other than just the cost of meeting, like the time that the lawyer puts in or the investigator puts in. So I can see employers pushing back if investigators say, no, I want to do this in person.
And with that, I mean, obviously, then there also comes different, with people working from home. I mean, all sorts of, what's your workplace environment? I mean, people are now, obviously, if you went onto like Facebook or Instagram or TikTok or whatever, depending on the age group there, and you're complaining about someone, right? I mean, that people often forget that, you're still part of the workforce there, if that can be seen publicly, right? So do you see changes and things like that, the way, how the workplace dynamic has shifted over the last couple of years?
I think the biggest change is that people go to the internet very quickly to, vent or raise their concerns, and they maybe circumvent the internal process that exists, either to get instant response or to get attention. So because they felt like they've gone unheard for a while. So I think that's a big change, is people no longer want to follow that policy or procedure that says you must complain to the HR person. I think the other thing is, it's difficult to separate, especially in the last 2 years, the workplace from the home. And people often forget that even if you're in your home and you're doing virtual work, that can be considered the workplace nowadays. And whatever you do there, it can be, if it impacts the workplace, it can be connected to the workplace, and it can be considered harassment. So I think maybe employees haven't fully appreciated that. And I actually think there's been an increase statistically as well of, incidences that are virtual in nature, because people kind of assumed it wasn't the workplace. So.
And so just last thing here on internal versus external, at what point do you think that, the HR person or whatever the policy, the procedure there, goes or needs to go from an internal person and go externally? I mean, do you find obviously that if it stays internally, then there's more of that potential for people disregarding the findings because of, well, hey, that HR person happens to be going to lunch every time with someone else, or whatever perceived bias that might be there?
I think the second that there is any potential to be bias, or the perception of bias, like it's just, if somebody has an honest belief that the person conducting the investigation internally could be biased against any of the parties, even a witness, not even necessarily the two main parties, then there should be a step back. I think in smaller organizations as well, it would be very hard to do an impartial investigation, because you're likely closer as a group in terms of relationships, and definitely in organizations where people have built relationships, or there's any type of familiar relationships. I've done investigations where people have been related, and the HR person is related to somebody not necessarily involved in the investigation, but in the workplace. And as soon as there's any of those relationships, I think that should be a red flag. Like, you shouldn't be touching those kinds of matters. So you should definitely be stepping back from that and seeking external advice on what to do.
And even just trying to obviously protect the company, right? I mean, someone internally may not be so out there about some of their findings because of the potential impact on everyone that could be involved.
Yeah, and that's something, that's why we always say to employers too, like, whatever you do with the report is up to you. I'm not involved in that. And employers always try to get some advice from us, and we always have to say no. Like, I have no interest in the company. I don't care. Not that I don't care. I shouldn't say that, but I have no vested interest in what happens. So if you make the wrong decision based on what I've said, and you end up getting sued because you took the wrong action, then that's on me because you took my advice. So I make it very clear, I'm not here to give you advice. That's what your external or internal counsel is for. They have your interests in mind when they're reading my report and saying, yeah, okay, we agree with those, what are we going to do about it? Or no, we don't agree, and here's why, and why we're not going to take steps, because they have the employer's back, and they're definitely worried about the bottom line, whereas I'm not, and that's why you've hired me.
So, Amanda, thank you so much for taking the time here, sharing a lot about workplace investigations, as well as your work there in ALS before there. And I think it's a lot of valuable insight for students. It's finding it's fun to end with some final words of wisdom for the students there. Anything there to kind of wrap up what you've said? And thanks again for joining us.
Thank you for having me. I think we hit it before, but there's no set course. I think we all go through school thinking we're going to do one thing, and maybe we do dedicate a portion of our career or our life to that, but there's so many paths out there, and the work that you do in one contributes to the work that you do in the next. All of it may seem like a big disconnect between being basically a staff lawyer to being kind of in-house at an organization to being a private bar lawyer, but they're all interconnected. And so even if you make different career jumps, what you take from one will lead you to another and will help you in your next career. So not to get upset or stressed if you deviate off the path that you thought you were going to take, because as long as you're happy in the work that you're doing and you feel confident in the work you're doing, I think there's value there.
Perfect. So thanks again, Amanda. I wish you all the best, and take care.
Thanks, JP.